So you've gotten the restriction requirement in an office action. What do you do to address that? So there's two things that you can do. So the things you need to do when you get a restriction requirement is, first of all, you must make an election of the invention that you want the examiner to examine. So step one is you have to make what's called an election. The examiner is usually going to tell you which claims are related to what invention and what figures in your patent application specification are related to what claims and what invention. And so you'll usually make the election based on the claim numbers and in some cases based on the figure numbers related to those claims as well. However, there are two ways that you can make that election of the invention. You can make it with traverse, or you can make the election without traverse. And traverse is just a fancy legalistic term, and all it means is if you traverse, it means you disagree with the examiner is saying. And if you make the claim election without traverse, that means you're making the election and you're not disagreeing with the examiner in terms of there being multiple inventions. So in most cases, you're going to make an election of the claims without traverse. And then the claims that are not elected are withdrawn from the application. So technically, actually, there are three things that you need to do, not just two. But the third thing, I'm kind of lumping it into the first thing, which is when you make the election of the claims that you want the examiner to examine, you're also going to withdraw the claims that are not elected. So you're going to mark the claims in your response to the restriction requirement as withdrawn, meaning that the examiner doesn't have to examine those claims. Now, in some cases, there are some situations where the withdrawn claims can be added back in later. Those distinctions are very esoteric, but to give you an example of what I'm talking about, the claims that the examiner is asking you to elect from may be what are called species. And those species claims may have what's called a generic claim. A generic claim would mean that if that generic claim were allowable in the application, in other words, if the examiner finds no prior art or you're able to argue against the prior art and get that generic claim allowed, the generic claim would cover all the species that the examiner required not to be examined in the initial examination of the generic claim. So if the generic claim is found to be allowable, the examiner then could do what's called rejoinder and allow the species claims to also be allowable with the application. But that's not applicable to all situations where there is a restriction requirement, but it is applicable to quite a few of them. So the other way that you can make the election is with traverse. So with traverse, as I mentioned, means that you're disagreeing with the examiner. In that case, what you would be arguing to the examiner is that even though you're making an election of this set of claims, specific set of claims, you disagree that a restriction requirement was necessary because the claims that the examiner is requiring you to choose from are obvious variants of each other. But why would you want to make that argument? If you make the argument that your claims are obvious variants of each other, then it might make them less enforceable. It might make the claims less desirable. It might be better to just let the claims that the examiner is examining go through that process and see if they're allowable. Now, if they are allowable, what do you do with those withdrawn claims? Again, in the case of generic claims and species that I described briefly earlier, the claims that were withdrawn could be brought back into the application. But what if the two inventions are really distinct, where they're not species of a generic claim and they're really distinct inventions? What would you do in that situation? There's a solution. So the solution to what to do with the withdrawn claims in your application, if the claim set that you elected in response to the restriction requirement became allowable, then that set of claims would go to issuance as an issued patent. So what do you do with the withdrawn claims? The answer is you file what's called a divisional patent application. Now, a divisional application is another patent application. you have to pay another filing fee and all the other fees associated with that application, but you would be limiting that application to the claims that were withdrawn in the previous application, which I'm going to refer to here as the parent application. So the parent application would be the first application that you filed, and then any applications stemming from that, such as a divisional application, would be called the children of that parent or child applications. So you would file for each claim set that the examiner considered to be a separate and distinct invention. You could theoretically file a divisional application for each one of those claim sets independently, and if they're allowable, you would have a patent issued on each of those claim sets filed in those divisionals. Now, the divisional application is the same thing as what is called a continuation application in the sense of the procedure for how it's filed and what happens to it during prosecution. So from the standpoint of what a divisional patent application is and how it's handled by the USPTO patent examiners, it's handled exactly the same way as a continuation patent application would be. And so for that reason, I would say take a look at my video linked here about continuation patent applications. So in terms of the structure of the patent portfolio that you would be developing, you would have what I'm calling a parent patent that would issue with a first claim set number 1, and that would be the claim set that you elected for the examiner to examine when you got the restriction requirement. So if those claims are found to be allowable and it goes to an issued patent, then you would have the parent patent having claim set 1. Now, before that patent issues, you would have to file what are called the divisionals on the other claim sets. So you could file at the same time, if you wanted to, 2 child patent applications. They're children of this parent, where depending on how many inventions the examiner determined that you had, you could file a divisional patent application for each of those claim sets as a separate application. So you could have a child divisional patent application with second claim set 2, another one with claim set 3. Again, depending on how many claim sets you had in the original parent application and how many of those claim sets were determined by the examiner to be independent inventions. Now, if you've watched my video about continuation applications, the one thing to understand is that if you wanted to, you could also file continuation applications from this parent claiming subject matter that wasn't claimed at all in the first application or in any of these divisional claim sets. So if you had additional support for subject matter that could be claimable, there could be divisional applications as well as continuation applications related to that subject matter. In fact, after this divisional claim set is filed, you could file a continuation from that divisional application claiming additional subject matter. So there are a lot of branches that can occur from the parent patent application depending on the subject matter contained and disclosed within it. But in general, the main takeaway from this discussion is that if you file a patent application having multiple inventions and you claim those multiple inventions in the same patent application, you're most likely going to get this restriction requirement from the examiner, which is going to force you to elect one of the inventions to be examined. And then after that, if that claim set is allowable, or even if it isn't found to be allowable, you can still file divisional applications that are directed to the other claims that the examiner defined as separate inventions and try to prosecute those claims through to allowance. So you have a lot of different options. Another takeaway from this video is that a divisional application, which is one way to address the withdrawn claims that were withdrawn because of a restriction requirement imposed by the patent examiner, is the same kind of an application as a continuation patent application in terms of the procedure and the way that patent application is handled by the USPTO. So if you have multiple inventions, should you file all of those inventions in a single patent application or not? Well, there's a strategy consideration and there's a cost consideration. If those inventions can be disclosed and they're somewhat related to each other, and I would say if they're related to each other enough that it logically makes sense to have one specification that talks about the subject matter of those different inventions. The drawings generally are related to each other, so that even though different drawings might disclose a different species or a different specific invention, the drawings overall have a relationship to each other, then I would say it probably would make sense to file all of that in a single specification and drawing set. And then what you can do is, when you file the application, you file it with a first claim set towards one of those inventions. So you have your 3 independent claims and 20 claims total, and you pay the utility filing fee for that claim set, and then see what happens during prosecution. And then later on, you can decide to file continuation applications from that initially filed parent application. And in those continuation applications, you could claim that subject matter separately in those continuations. If you file all the claims for the different inventions initially, again, as I mentioned, it's likely you're going to get the restriction requirement, which is going to force you to file those additional patent applications anyway as divisionals. So if you file more than 20 claims in order to claim these different inventions, or you have more than 3 independent claims in order to claim them, it's a cost consideration because, again, you're going to have to pay USPTO fees for any independent claims over 3, and you're going to have to pay additional claim fees for any total number of claims over 20. So if you have a large number of claims in your application because you're directing it toward different inventions, you might want to look at filing one claim set toward one invention initially, and then filing continuation applications later. You might find that the claim fees that you have to spend are more than it would cost you to file separate applications for those separate independent inventions. The other thing to keep in mind is that if you file those inventions together, hoping that the patent office will just go ahead and examine them, which is also possible, the examiner doesn't have to issue a restriction requirement. It's not a necessity for the examiner to do that. If you get a restriction requirement because you had a large number of inventions and you had a large number of claims for which you paid these extra claim fees that I'm talking about, those claim fees are gone. You can't go to the USPTO and request a refund for those claim fees, and you're still going to have to file the divisional applications or continuations in order to claim that subject matter. So you're ultimately going to wind up having to pay additional application fees, and those extra claim fees that you paid for extra independent claims or extra claims over 20 is going to be money that's lost. You're not going to get that back if you get into this restriction requirement situation. So from that standpoint, I would recommend probably take a really close look at if you do have different inventions in the application. It probably would be better in most cases to have your initial claim set and your initial application directed to a single invention. And if you think you have multiple inventions disclosed, go back later and file continuation applications for those inventions rather than getting the restriction requirement and then losing any excess claims fees that you paid and then having to file divisionals anyway. I hope this all makes sense. It's a lot of information, and I know it can be very confusing, especially this idea of divisionals versus continuations. Feel free to post questions in the comments below. It may become subject matter for another video, or I may be able to answer your questions in the comments. If it's something that I can answer within the constraints of the comments, I'll be happy to do so. So again, thank you for watching this video, and I'll see you in the next one.